understood that, but as far as Ms. Bradley being here, she has co-counsel, and her office has some approximately 200 lawyers. So, I mean, with all due respect, she has co-counsel that has been with her throughout the trial and the pre-trial motion. So I'm just advising.
I'm just telling you on the motions, that third week before the October 2nd, I'm not going to be in the building.
Fair enough. I thought you were celebrating my birthday.
With regards to Mr. Bostic's case, I don't anticipate it finishing by the end of September because we didn't realize that Monday we were off, and there's 2 additional witnesses that are calling this time that did not call last time. So I'm scheduling.
On the motion for bond, we're in agreement to deny bond is higher than a reasonable doubt. Proof evident presumption rate. And that's what her cases basically say. Certainly, since the jury could not reach upon the evidence Your Honor heard, they certainly cannot carry the burden of proof evident presumption rate, which every case that she attached to her motion says is the proper burden. I would also bring the court's attention to, she wants the court to look at certain exhibits and testimony. And you've heard all the testimony, but she included witnesses that are either lost, unavailable, or she cannot find. And certainly the court should not consider any of those witnesses. Specifically, Mariah Hamilton, Nikita Bagley, the Christopher Williams construction report, he testified. You heard his testimony. And all the other exhibits that Your Honor heard. So I think it's a really simple issue. The state cannot carry its burden of proof evident presumption rate. Therefore, the court has the right to set a bond. Melly was born in Florida, raised in Florida, has no passport. His mother is here, his family is here, as they have been here almost every day of the trial, as the court knows. And certainly we can structure a bond, including GPS and house arrest if necessary, which is the most restrictive. But at least give him an opportunity for bond because he is presumed innocent. And there's no way in heck the state, based upon the lack of a verdict, they can carry their burden of proof evidence presumption rate.
Judge, we have one case, if I could just jump in. It's a very short one, 2 pages. I'm handing the state a copy. And you're on the approach. It's kind of short. And it's a Supreme Court of Florida case decided, believe it or not, in 1945. And it's called State versus Freer. It's at 20 Southern 2nd, 481. The Supreme Court said that, and there's not much case law dealing with a hung jury issue as to proof evident presumption rate vis-a-vis. But this case specifically says it is an added factor and that the court on a bond hearing, an Arthur hearing, needs to take into consideration, and this upheld the fact that that court let a guy out on bond, a woman out on bond, after there was a hung jury that they couldn't decide beyond a reasonable doubt as evidence to show that there is no proof evident presumption rate. That case is black letter law since 1945. It's still law today. And we asked Your Honor, who heard, this court heard every bit of evidence And the state, I'm sure, didn't hold back other evidence that they had and didn't present to the jury to be able to prove beyond the exclusion of a reasonable doubt. They shot everything they had, and that jury was hung and could not find that there was beyond a reasonable doubt evidence. That's proof that they can't meet the higher burden of proof evident presumption. We'd ask Your Honor to consider that. We have a case where there's a co-defendant who's been on bond in perfect compliance with regulations all this time. Mr. Devins deserves to be out on bond too, with this added piece of evidence that shows that proof evident presumption grade status hasn't been met.
Thank you. Is there anything else you need?
When that issue
On bond response. I did receive I haven't looked at it yet. It just came into my office. A file. I haven't looked at it. I assume this is just exhibits that were in the trial.
In addition, Your Honor, all of these information was provided to defense counsel approximately back in 2019 when the initial discovery exhibit was filed. So none of this is new information to defense counsel. In terms of the statements and things of witnesses that did not testify, defense counsel was making a suggestion they are unavailable. Statements submitted, those are still allowed to be relied upon. But the problem that defense counsel has is they are arguing the wrong judge.